Good morning, Your Honor.
Good morning.
May it please the court. This appeal, it turns on one question.
Can you speak as loudly as possible? Maybe turn him up a bit. Thank you.
Okay. This appeal turns on a single question, and that's whether or not a non-conforming use can be limited to the unexpired or express term of a land use permit or of an operating permit.
Can you start with jurisdiction for us?
Sure. And I'm going to have to pull out my phone. So
Sure.
I forgot that it was an exhibit, and I said, no, it's not appropriate. And so basically, I think what we're getting at is the practical finality exception to the final order doctrine. And so I have a case, the servants of Marquardt versus Doe's, in which they stated, and I'm going to read it in pertinent part that applies to the damages judgment. Where there cannot be and there will not be any further proceedings in the district court as part of the same action, the district court's determination is a final judgment. So in this matter, the email is the key to whether or not there's damages. And the email said, it was dated the 28th, and it said on the 31st, you have to cease operations. Your permit expires. And that
let me pause you. Can you point me to the exact language in the district court's so-called final judgment that grants your client any concrete, enforceable remedy?
It is the remedy it granted was the takings clause. First, the court said...
So what relief did your client receive on that?
Okay, so the relief my client received was that from August 31st until her permit expired, the judge ruled that was a takings, right? So that was the constitutional injury was because what the city was trying to do was to stop her from operating, right? Saying your permit expired, and the judge said, district court said no. She had a vested property interest, she had a non-conforming use, and she was entitled, and that was a taking of her vested property interest to operate all the way until January 12th under her existing permit. And when the city did that, that constituted a takings. But the court issued injunctive relief which prevented the injury from the takings.
So your complaint sought a permanent injunction, correct?
It sought preliminary and permanent injunctive relief.
So can you point where in the district court's judgment is that request resolved?
It's the district court's declaration that a takings occurred. For the remaining time on her permit, that's where the takings occurred. The city was taking her rightful use of her property from August 31st until the permit expired on January 12th.
So you got a declaratory judgment?
Yes. And normally a permanent injunction is declaratory, right? But yes.
So if we assume the judgment is declaratory, and why doesn't Hignall-Stark, the Hignall-Stark case, why doesn't that case control and require that all forms of requested relief, including injunctive relief, have to be resolved before finality exists?
Well, I think the judge did resolve the injunction. He did not continue the injunctions. He said, my final... and my case was different from Stark's. My case was a land use case. Stark's case was maybe a due process case and other issues. But as a land use case, right, he said, I'm lifting the injunction. I don't recognize that your land use is ongoing, and so I'm not going to grant any further injunctive relief. And that was the finality to my case.
So no further injunctive relief, but there was an injunctive relief for the time period.
Yes.
Or it's limited time period. But it doesn't necessarily say all that in what the order that Judge Lamel entered, does it?
Well, in the record, he states he entered an injunction on August 31st, 2023, which continued until the February 27th or 28th judgment. And at that point, he says, I'm not issuing any further relief. I don't think, and the judgment says that there's I find there's nothing to support.
You filed a motion, correct me if I'm wrong, but as I recall, you filed a motion asking the district court to enter a final judgment because, quote, the judgment is not clear, unquote.
Right.
And does that undermine your position today that the order was final?
No, where I was saying the judgment was not clear was that the limitation of a non-conforming use to the term of the permit is not in the zoning code, and which was his written judgment. And at post-hearing argument, he changed he pivoted toward a different basis for limiting the term of the non-conforming use. That's what I wasn't clear on. I said, how did you come up with that? It's nowhere in the code. There's no case except Seal-Fletty, which rejected it, an out-of-state case.
Would you oppose a limited remand to the district court to clarify that all relief not granted was denied, or to clarify what actually happened?
I don't think it's necessary because...
And I'm not saying we're doing that, but go ahead. You don't think it's necessary?
Well, I don't think it's necessary because there's basically...
You asked for injunctive relief in August, and you got that granted, essentially. So you got the relief you asked, but not all of the relief you asked. The district court said, you get an injunction until the end of the permit. That happened, right?
Mm-hmm. Yes.
And then the judge says, but you lose on the rest of your case.
Yes. I won because I had a constitutional violations for a limited time.
Takings claim for a particular period of time.
Yeah.
And the injunctive relief kept your client whole for that period of time.
Right.
But you have no further claim because the judge said, going forward, you have no...
Right. He said because the permit expired.
So everything you asked for after after the February hearing or whatever, the judgment, was denied.
Right. He just made his February 27th order final.
Right. So you got some relief, just not all the relief you asked for.
Right. And I think I didn't get that relief.
And it was denied.
Right. And that's why I'm appealing that denial, because I believe it was contrary to law.
And so let's talk, unless there's something further on the jurisdiction, let's talk about what you're appealing in the merits here. Is it the fact that you got declaratory relief or injunctive relief as to that time period the reason that you believe you're entitled to attorney's fees?
Yes.
Okay. Did it affect the behavior of the defendant towards the plaintiff? The Supreme Court requires that in order to get fees. How did it affect the behavior of the city towards Marquardt during that time period?
During the litigation, the issue came up. Can she operate? There's an injunction issued, and the city even went on the record to say that, yes, during the injunction, we understand that she can operate and she can...
So she was allowed to operate when the city otherwise would have closed her down.
Right, right.
So that affected the behavior of the defendant, kept them from closing her down during that time period.
Yes.
Okay.
Yes.
And again, that time period was how long?
It was from August 31st until she had 2 permits, one expired January 12th and another January 20th. So through that time period, she was in legal operation, but the injunction didn't end until February 27th because after the permits expired, the injunction was still in place. She continued to operate. And remember, we didn't know what the outcome was going to be. So she's operating. If we win, she continues to operate. If she doesn't, she has contractual obligations even beyond
Well, in other words, it wasn't that she was entitled to something legally that the city was opposing, that she got extra time. It was just because the court hadn't reached a conclusion yet.
Well, no, she got the time left on her permit.
Right.
See, the city was rescinding her permit early. So we're rescinding all permits. We're taking your permit. We don't care if you have a permit or not. You got to stop.
They're pulling all the permits.
Pulling all the permits. Right.
And the city couldn't pull her permit because the judge said that would be a taking.
Right. They couldn't pull anybody's permit.
Yeah.
Right. That would be a taking. Right.
So is that all you're seeking here? Is these fees?
No, I'm seeking
What else do you want?
to reverse the finding that the expiration of a permit limits a non-conforming use.
Limits a non-conforming use?
Yeah, that a non-conforming use is limited to the express term of a permit. That is not the law.
He says that their position.
Go ahead. I'm sorry.
Yeah, because if the non-conforming use doesn't expire when the permit expires, it continues on. And that is well-established law throughout the country. And I only found that one case, C.O. Fletty, in another state that flatly rejected that the expiration of a permit ends non-conforming use. And that case stated just the opposite. It would frustrate non-conforming use. Because non-conforming use is constitutional under Louisiana law. The Louisiana Supreme Court has held it's a doubtful constitutionality to require the immediate termination of the use of land when the law changes. So that's what I'm hearing. And if we get that reversed, she operates as a non-conforming use, like hundreds of non-conforming uses do in this city. And that's why, and I know y'all didn't speak to my exhibit, but one of the exhibits, I don't know if you're going to accept it or not, but I'll just describe it. This is a land use study that the City Council is going to discuss on Tuesday, or the Planning Commission. And it's going to require that commercial short-term rentals will be able to have their permit revoked, their non-conforming use. They say, well, let me read it. It says, when and if new regulations are codified, several of these existing uses may become legal non-conforming.
But how is that? I'm sorry, and I apologize, because I thought it was limited to a certain time period. They did it for three or 4 days in August, but during the whole time until the next year, she was able to use the permits. So how is that still relevant here? I'm sorry.
He's saying that forever, that a city cannot, if it's a non-conforming use, it's basically in perpetuity.
Right.
That just because the city passes a new ordinance, that she has a right to have that non-conforming.
That you're grandfathered forever.
Yes, exactly. Sorry. Like Antoine's Restaurant, Hermes Bar, case I cited. Jim Durgis's bed and breakfast at Escalade in Broad. He's grandfathered, and it lasts forever. Clancy's Restaurant. I mean, the city's most corner stores, maybe even this courthouse is grandfathered. I don't know. But and that's what I'm hearing about it. And it's universal across the country that a non-conforming use only ends if it's abandoned, it's discontinued, it's destroyed, or the city adopts an amortization ordinance that says you have so much time you can recoup your costs, right? And non-conforming uses are created when the law is changed, or there's a Louisiana revised statute that would be frustrated if this is allowed to stand. If I'm using a use illegally, the city knows about it, has noticed. I operate for 5 years, the city's action prescribes, and I become a non-conforming use. But what use would that be if, at my 1-year permit cycle, the city says, oh, your non-conforming use ends? Or why would I ever litigate a non-conforming use case if it will end before the litigation is over?
Well, how do you deal with the Red Fern case?
Okay, yeah, I'm glad you asked that. Okay, Red Fern says, so Judge LaMelle said, I limited your permit to the term, I limited your non-conforming use to the end of the permit. He said that's in the zoning code, in his written judgment. But then that post-hearing argument, he says, no, that's in the Redfern case. I use the Redfern case as narrowly construing. So the way narrowly construing works, the neighbors, there's Hermes Bar, Antoine's Restaurant. They had live entertainment. It was going off and on. The neighbors said, no, it wasn't regular. It ended. They lose their non-conforming use. It ended for 180 days. Antoine said, no, we do it regularly. So in that case, when you have competing arguments and facts of whether the use continued, the court can narrowly construe the argument, the facts against it continuing. It works. You look back at use. You don't say, I'm going to narrowly construe you going forward.
So you're saying separate and apart from the permit, she has a right to use this non-conforming,
yes.
And they can never change that. It goes into perpetuity.
They can do an amortization ordinance, which they did in the 1920s, the Dimmer Realty cases.
But they can't do it through an old municipal ordinance or zoning ordinance.
No, the zoning code specifically says, notwithstanding any provision to the contrary, basically says when you change the law, you have an existing use, and we make a law that's more restrictive, you become a non-conforming use. And the first 5 words are notwithstanding any provision to the contrary.
Okay, thank you. I believe you saved time for rebuttal, sir.
Okay.
We'll hear from Ms. Hutton.
Good morning, Your Honors.
Good morning.
Please, the court, would you do you want to hear from me about the jurisdictional issue?
Yes, please.
Okay. Initially, when the city briefed this matter, we were under the impression that, there had been a judgment and we were moving on. But after the court brought it up, and we went back and did a thorough look at the record to see. It has a very long procedural history going back a number of years. And I went back to the beginning, and I looked at Judge Lamel's judgment, the February 28th, 2024 judgment. And Part 15, this is record 3518. He says that based on a reading of the record, it's likely that the damages from Marquardt are limited to August 28th to August 31st. However, the court reserves the issue for later determination. She seeks monetary damages and equitable relief for the unlawful taking of her vested property. She argues for an extension of her permits beyond the resolution of instant motions. The request lacks factual and legal foundation. Even if discretionary authority to order such an extension, there was no showing to warrant that extraordinary relief. To consider the request for monetary relief, including related attorney fees and costs, separate motions must be filed. So then he reiterates that in Part D, which is Record on Appeal 3518 to 3520. Because plaintiffs have prevailed on some of the substantive claims as noted above, they may be entitled to limited damages, attorney's fees, costs, and possibly other awards. Accordingly, no later than March 29th, 2024, they may file appropriate motions and notice same for hearings in accordance with federal and local rules.
Right, but they only filed the one motion, and then the court said the motion's denied in all of the respects.
Well, and then
says that orders a final, what appears to be a judgment that says the motion for summary judgment is hereby granted in part, and then all it appears to be all the other relief is denied.
Are you looking at the judgment that's
February 28th? That's after the motion was filed on the fees, after the other order on March 29th. So the March 29th
Right.
said file something else if you want to file something else. They did file something else, and then the court said, bam, here's, so.
The court denied it. At the hearing of March 27th, and said that,
and then November 25th, 24 wraps it up.
What's very interesting about that order is Judge Lamel mentions the February order in it. He sort of rolls all of that.
So he's trying to put it in a bow.
He's trying.
Don't you think he's trying to tie it up with the bow and end the thing?
Well, I think he wanted it to be briefed, and it didn't happen.
And so he says we're done here now. No more motions were filed, so we're done. Would the city oppose a limited remand for the district court to clarify that all relief was not granted, was denied?
No, I'm not going to object to that.
Does the city require that?
I just think under the case law, actually I know under the case law, that if a judge, for something to be final, and this even happened in the Hignall opinion from this court, there was a claim hanging out from the city where we had brought a cross appeal on something, and the court came back and said, well, you haven't really pled this out, but it's still hanging out there, and,
I thought the judgment in Hignall Stark was nearly identical to the one issued here. Is that wrong?
Well, part of
in Hignall Stark,
it's all part and parcel of the same thing. The ruling in Hignall Stark is we're changing the ordinances on that govern all of this, and why a non-conforming use is not to be had in perpetuity. That's not something.
But I thought in Hignall Stark there was a nearly identical judgment, and we held that it was not final.
That's the judgment that I was looking at. Yes, what they said, and then they bounced it back. I have that right here. In the Hignall Stark, they said, pardon me. In that Hignall 22, August 22nd of 2022, it said, hence, we previously have rejected claims of finality when a district court granted a declaration but failed to resolve the plaintiff's request for other relief. And that's ROA 2077 to 2078.
But what claims for relief were not resolved in this case? Because
in this case?
Because in this case, the judge said, if you want X, Y, and Z, you need to tell me by a certain date. Mm-hmm. That date comes, and they said, we want attorney's fees. They didn't ask for anything else. And the injunctive relief allowed her to continue to use the property as she had been using it. They didn't seek damages. So at that point, what claim was left other than for attorney's fees?
I think Judge Lamel thought that there was a dollar amount for those few days. I don't think he was aware that.
But didn't he say, file a motion if you want that?
That is what
and they
he said.
did not file a motion.
They did not file it.
So he said it's over.
He didn't say that.
That is very much, if you read all of the orders, there's no damages, it's done. There's not dangling out there whether she can get damages.
I defer to the court.
Okay, let's get to the merits. We'll have to sort this.
Yes.
Let's get to the merits.
It just never said, that final directive, that this is, it never said that.
We'll sort through that, and if we have jurisdiction, let's hear the merits.
Okay. The reason that, despite Ms. Marquardt's protest to the contrary, there is no perpetual non-conforming use. And that is because the CCO specifically prohibits grandfathering or non-conforming use status for previously issued STR permits. STR permits, it's a privilege, not a right. They come to an end. In this case, it came to an end. Her permit came to an end. She went to the lottery like everybody else has to do, and she didn't win the lottery. So you're only allowed to have one per block, as you all are aware. And we're in the process of codifying all of that into our code, and that's the way we're enforcing it now.
So does it matter that she had that right from the permit as opposed to some other pre-existing right before there even were permits?
All of her intermittent use doesn't translate into a non-conforming use. It doesn't.
So she can't argue that it's not, the permit is not what gives her the right to the non-conforming use. I had that right anyway.
Yeah, she can't argue that. Yeah. Because we had, we started having permits, started having legal short-term rentals in 2017, and people had permits.
But she had it, did she have that before? For that, did someone have that for that?
The record is, again, this is part of the problem that Judge Hamel had with Ms. Marquardt's case, is that, those facts were not established, and they're not part of this record. So,
if the facts did show that she had it before, would that change your answer to my question?
No, because the permits all have a time limit. They're all for a certain period of time.
Well, let's have a hypothetical, make this more clear. I own a house, and I've owned it for 40 years, and I do short-term rentals out of my house. And then the city of New Orleans says, we're going to start regulating short-term rentals, apply for a permit. I do, but I've been using it for short-term rentals. Illegally, but before that. Now, is that a non-conforming use?
Still would not, I argued something about this recently, an illegal use, because you weren't allowed to do short-term rentals prior to 2017. So an illegal use would never translate to.
Well, why do we even have cases about non-conforming uses? You must give them an opportunity to recoup their money, da-da-da-da-da. What about those? How do we square those cases with, if it's non-conforming use, we can terminate it at any time?
In regard to a permit, because the code says that. It says.
Well, you're missing the point here. If, let's say, there was no permitting required, then you come in and say, well, I've been using this for 40 years. You say it's non-conforming. What law do you have to follow to terminate my non-conforming use that I've been using all these years?
It's 21.8C18. Short-term rental non-commercial. That's not,
just forget there's a short-term rental permitting scheme. There's no short-term permitting scheme. I am using my residence. I'm making short-term rentals. The city never has regulated it, ever. And I've been doing it for 40 years. They come in and say, stop your non-conforming use. Now, what is the law? What permits the city to say, boom, you don't have to take into account any of these factors? Any factor at all.
The city is allowed to make rules about the use of people's property for a commercial use, which is what this is. It's not just living in it. It's not a residential use of property. It's a commercial use of property where you're renting it out, to somebody else.
But under Louisiana law, is it a taking if you, or some other violation of the land use, if you have a long-standing practice, separate and apart from permitting, and you're told you can no longer do that?
Well, I don't think that's the case.
We're actually hypothetical here.
Okay, but I just want to make sure that I'm clear.
You say this is only under permitting. We got it. But in the hypothetical, it's a pre-existing. It's been in existence for a long time.
Under our code, an illegal use never, ever, and I didn't brief it because
does it make it an illegal use?
It is illegal because there were no legal short-term rentals in Louisiana, in New Orleans.
Before there was a permitting regime.
Before that, even before that,
It was illegal?
It was illegal, yes.
Since when?
Prior to 2017, it was illegal.
Since when? Like in 1920, was it illegal?
As far back as I can see, I mean, I didn't brief this today, but there's a whole body of
Which is
law.
what makes it a non-conforming use, right? That's what makes it a non-conforming use. Now, what does the city have to do to cease a long-standing non-conforming use?
I'm having to remember something that I argued, at the Fourth Circuit like several weeks ago. So you're going to have to forgive me because I'm not prepared for that. But as I recall, we had a case, and the person had to show, there were like so many years of continuing use, and that it didn't violate any of our laws. And I want to say it had to be something like more than 10 years. But then you still, even with a non-conforming use, you have to, which is not before the court right here, because there's another case bobbing along for special exception for the same plaintiff at the Eastern District. One must go through a process with where the neighbors are allowed to come and make comments about, how they feel about this continuing in the neighborhood. And then they do like a planning study. And there's a whole big rigmarole that they go through for that before, it gets denied. But again, that's not before.
Well, see, that's what I don't understand. We just asked you the question 10 minutes ago, or at this point, we said, is there a fact question about what was happening with the property before there was ever this code scheme regulating non-conforming uses? And you said that's not clear. The facts aren't in the record. So,
well, they're not. They're not for the purposes of. That's my understanding is what we're here to argue, and then what the judge at the district court had before him was what was in the record.
I thought, maybe I'm wrong, I thought their argument is we had some pre-existing use before the short-term rental regime, that we had a non-conforming use that pre-existed that, and that the fact that you come in with a short-term rental scheme and we got a permit doesn't wipe out our pre-existing non-conforming use rights. I thought that was their argument.
The procedural history of the case is that she obtained an initial residential short-term permit on April 1st of 2017 and had been operating continuously for several years.
So we don't know whether, we'll have to ask them whether they have that in the record or not.
And I think that's why Judge Lamel had the problem, is that she hadn't made a factual basis.
A showing. If she had have facts that show that it existed before the permitting scheme, then we'd have all these issues that we're talking about now.
If I don't know what those, I don't have those facts. It's hard. And
I just said if she showed that she had an interest before the permitting process, then it would become a more complicated question.
It would have to be a more complicated. They would need to be briefed. Yes.
Okay.
But that's not what we're looking at, and that's another reason why it kind of felt like maybe it wasn't a final judgment. But.
Well, that's what I don't understand. Either it was an issue or we have a final. Either it was an issue or it wasn't. I mean, I don't understand what you're saying.
If it wasn't ever talked about, it wouldn't affect the final judgment. So it has to be lurking for it to affect the final judgment. But I thought you're saying it's not lurking.
She didn't have a non-conforming use that was grandfathered.
Okay, so it's not lurking.
It's not lurking.
Okay.
Yeah. And under, our ordinances, which we're allowed to do, we're allowed to regulate non-residential uses of private property as the city. We're allowed to do that. And that's what our, in 21.8C18 says. No provision of this shall be construed to authorize the continued use of any property as a short-term rental in the event the city modifies its short-term rental permitting regulations. That's what it says. And we did change the law. And she went to the lottery, and she didn't get what she wanted. A lot of people didn't. So, because those are the rules.
Okay. Do you have anything further?
Attorney's fees. I don't believe it is our position that in a situation like this where the appellant has no damages, that it is a de minimis finding, and they would not be entitled to attorney's fees.
Under the Supreme Court precedent in Rhodes v. Stewart, a declaratory judgment entitles you to 1988 attorney's fees if it affects the behavior of the defendant towards the plaintiff. Did it affect the behavior of the defendant towards the plaintiff between August and January?
No, because she was allowed to continue to use her license.
Right, but she would not have been separate and apart from the declaratory judgment.
That is true.
So it did affect the behavior of the defendant towards the plaintiff, the relief she got and prevailed on. Because you would have stopped her right there, not you personally, but she would have been stopped in her tracks right there in August.
Except that the court told us that we couldn't do that, and so the city...
That's why she did get relief under the declaratory judgment on the takings claim and would be entitled to attorney's fees. What am I missing?
Because there was a zero award.
Damages does not determine attorney's fees. For declaratory or injunctive relief, damages can, in most cases it does, but it doesn't in every case. In some cases, injunctive and declaratory relief, where it affects the behavior of the defendant towards the plaintiff under binding Supreme Court precedent, that determines whether attorney's fees are appropriate.
I would argue that the appellant has made a judicial confession that she didn't have any damages.
But damages is not dispositive. So how does that affect your argument?
Yeah. Relief is broader than damages.
What was how many days was there a taking? According to the district court's judgment, how many days was there a taking?
3 days.
Okay. But so he did find a taking for 3 days.
For 3 days.
And it affected a course of conduct for months. She wasn't stopped in her tracks on the permits for months.
That is correct.
Okay.
She continued to operate.
Which she would not have been allowed to do.
The court, the court had...
If the court had not said you must let her operate because she still has that permit, you would have stopped her earlier. Yes.
Yes, and then the court gave the directive where we had to let everybody.
Right. I'm not her personally, but
everybody. Yeah.
Thank you.
Okay,
we have your
thank
argument. Mr. Washington, you've saved time for rebuttal.
Yes.
Can I pester you with one more quick jurisdiction question? Yeah.
Oh, yeah, go ahead.
So after the district court issued its February 24 summary judgment ruling, you filed a motion asking the court to enter final judgment or to certify the ruling as appealable?
No. What happened, I filed a motion for attorney fees.
Okay.
We litigated that, and I didn't file a purposely didn't file a motion for damages because I didn't see any damages. The email says, dated the 28th, you don't have to cease until August 31st.
So maybe I misread something. Hold on a second. I thought you had filed a motion after that summary judgment ruling asking the district court to maybe certify the ruling as appealable.
That was Dawn Wheeler in the Ignal Starks case. She did that.
That was Ignal Stark.
Right, that wasn't.
Okay.
Yeah, she wanted an immediate.
Because to me that says
Right.
you didn't think it was final and appealable, but I get it. Okay.
This is why we had the attorney fees litigation that lasted until the end of October. October 31st, we had a hearing. After that, all issues were resolved. There was no more hearings. So a month passes. I call the division. I said, is the judge going to issue a final judgment? I called in November, around the beginning of November. A few days later, he issues a final judgment.
Okay, go ahead.
So that's kind of behind the scenes, because I needed to appeal. I said, can I get a final judgment?
Yeah.
And so, and there was no, see, the email said on the 30th, you must cease on the 31st. And that's what the ordinance said. So I would have had damages, but then the injunction prevented the injury. And so no injury, no damages. And so no need for me to file a motion for damages because my client was never injured. She operated before the rescission date until the 31st. Injunction granted, preventing injury, and she continues to operate, so she's not damaged.
Okay, go on with what you wanted to say.
Do you have a position on whether your client had a non-conforming use prior to the permitting process in this lawsuit?
Okay, in 2017, the city passed ordinances allowing short-term rental by right. So that's where her permission to use it. It was by right in the zoning code. And then in March of 2023, they took that right away. And that makes her grandfather. When the city changes the law, like you have a house, and he said you can live in a house, of Judge Richman, you were saying, then you're living in it for 40 years. If the city changes the law on you and says no more single-family homes here, you're grandfather.
But if it's just a right that's created vis-a-vis the permitting process, is it really a right, or can it be taken or given at the whim or the direction of the city?
No, it's a constitutional right.
Is it a constitutional right if it's just a right through the permitting process?
No, if it's just a right through the permitting process, well, let me back up on that. What the city stated is not correct. There was no law that said a short-term rental could not become a non-conforming use until they adopted the ordinances in March of 2023. So what she's really saying is that they're trying to apply those laws retroactively. The law that she's citing was a new law that I'm fighting, that I'm saying she's grandfathered as to that law. And that law does not apply retroactively. That all came into existence as part of this litigation, as part of the new ordinances. And nothing said it was going to apply retroactively. And also it would violate separation of powers because the Supreme Court says you can't, it's non-conforming use is constitutional. You can't by ordinance trump what the Supreme Court says is constitutional. And then it...
How is there a constitutional right here?
Because Redfern says non-conforming use is to prevent the doubtful constitutionality of requiring the immediate termination of uses already in the area and the hardship that would ensue, and therefore the use continues as a legal non-conforming use. And the zoning code says that. The zoning code says notwithstanding any provision to the contrary. And see, that creates a conflict in the zoning code. The thing she read about no non-conforming uses, but the provision in the zoning code is still saying, yes, there is non-conforming uses.
Thank you. We have your argument. We appreciate both arguments. The case is submitted. This ends.